My name is Therese Ballou. I'm a senior at St. Mary's, majoring in music, political science, and philosophy, and I plan to go to Ave Maria Law School next year. Our next speaker, Professor Carter Snead, is an associate professor of law at the University of Notre Dame Law School. In 1996, he received his BA from St. John's College and his JD magna cum laude from Georgetown University in 1999, where he was a member of the Order of the Coif and associate editor for American Criminal Law Review. Following law school, he clerked for the Honorable Paul J. Kelly, Jr., United States Court of Appeals for the 10th Circuit. He then practiced with Wilmer, Cutler, and Pickering, and with Ropes and Gray, both in Washington, D.C. In late 2002, he accepted the position of General Counsel for the President's Council on Bioethics, a White House Advisory Committee we've heard about. As General Counsel, Professor Snead advised the Chairman and Council members on the legal and public policy dimensions of numerous ethical questions arising from advances in biomedical science and biotechnology. He was the principal drafter of the Council's 2004 report, Reproduction and Responsibility, the Regulation of New Biotechnologies, a comprehensive critical assessment of the governance, both public and private, of the activities at the intersection of assisted reproduction, human embryo research, and genetics. Professor Snead continues to serve as counsel as an expert consultant. From 2004 to 2005, he served as the chief negotiator and head of the United States delegation to UNESCO for the Universal Declaration of Bioethics and Human Rights, adopted in October 2005. Professor Snead was recently listed in UNESCO's Global Ethics Observatory, a worldwide directory of experts on bioethics, environmental ethics, science ethics, and technology ethics. His research focuses primarily on the intersection of law, science, and medicine. He is currently working on an article exploring the impact of recent advances in cognitive neuroscience on capital sentencing. Please join me in welcoming him.
Thank you all very much, and thank you for that kind introduction. And thanks to the Notre Dame students who put this together, and all the students from everywhere else, and presenters who have taken their time to contribute to this very enriching and excellent program. It's a terrific program. We've heard a wonderful diversity of voices from a variety of different perspectives, and that's crucially important if you're going to have a rich understanding of bioethics or any academic subject. So you guys, I'm also glad that the Notre Dame students are here, because this is the beginning of their spring break, and they're not in Cancun or Daytona Beach. They're instead here at McKenna Hall listening to me talk about bioethics. I'm a lawyer, and I think that if memory serves, I'm the only lawyer that has spoken to this particular assembly. And if I'm mistaken about that, I apologize. But I am a lawyer, and lawyers sometimes make people nervous. Law professors less so than practicing litigators. But you might be asking yourself, why is a lawyer here to talk about these matters, or to weigh in or wade in to these particular important questions that we've been talking about? We've heard from eminent philosophers like Dan Maher, talking about the moral principles that should govern our actions in this particular domain. We've heard from eminent practitioners like Paul McHugh and Bill Hurlbut. We've heard from research scientists that have covered the practical context in which these difficult ethical questions arise, and have sort of tackled the question of how we should govern ourselves morally in this very specific context. So why a lawyer? Why would you have a lawyer come and talk about this? Well, I'm glad to be here to talk to you, and I think it's important that you hear from someone who is within the law, because all of the question of how we govern ourselves morally and ethically as individuals is really a precursor question to another question that invariably arises, and that is interesting, especially interesting to people like me, namely, how should we govern ourselves as a people? How should we govern ourselves as a polity, as an American public, as a democracy, with respect to the questions of bioethics, particularly in a pluralistic society like ours? Law is everywhere, for better or worse. Law is everywhere. Law mediates our relationships between one another. It protects us from one another. Controversially, in some cases, it protects us from ourselves. It encourages certain behaviors through endorsement, or federal funding comes to mind as one means of endorsement for encouraging certain behaviors. It deters certain behaviors through criminal proscription or through the erection of certain obstacles that one has to overcome in order to engage in a certain enterprise. The law speaks. The law reflects our values. The law shows what we take seriously. It shows what the American people take seriously. It shows what goods, it reflects the goods that we want to pursue. It reflects the harms that we most want to avoid. But it doesn't just reflect our moral values. It also, in many respects, informs and teaches us with respect to what our moral values should be. Not just what they are, but rather what they should be. People take from the law lessons as to what is right conduct. People, and I'm not in any way suggesting, and I would warn strenuously against the notion that if it's legal, it's moral, because that's certainly not the case. But there is a deep, deep connection between the moral and the legal, as I'll get to in a moment. So, and all of this is powerfully true in the context of science and medicine. Science and medicine give us enormous powers, give us enormous technical powers to subdue nature, to remake our own nature, to heal ourselves, to become better. But these are powers, and as techniques, they don't in any way suggest to us how they should be used. They're silent on that question. They're utterly silent on that question. And so it is, in the first instance, left up to us in discussion about what's morally required and ethically required in this particular domain, to figure out how we're going to use these powers and to what ends we're going to direct them. But then secondly, it is up to us to figure out, to take these moral judgments that we come to in our deliberative process, and then enshrine these judgments in the law, and memorialize them in the law, and infuse them with the coercive power of the state, to compel people to bend their will to the moral judgments that we've made. And this is true in science. We love science. We love science. We love medicine. It's always been true. But science and medicine are subject to the strictures of the law, both to promote them and to restrict them. And where there are bioethical questions, there will invariably be lawyers at 5 o'clock on the last day of the event. So, my charge today is to talk about the future, to talk about what is on the horizon, what ethical questions are presenting themselves to us in the near future. And I propose to do that in the following way. I will describe to you first, and reflect on for a moment first, where we've been. I'll look back briefly to what we've done in this very young new century, what's happened, its relevance to questions of bioethics, and what we've been talking about for the past 2 days. And it's in the seeds of our future challenges lie in these particular contexts. The contexts are the same, the challenges are different. So I'll briefly meditate on what we've seen, what we're grappling with now, and then I'll describe to you, and I won't be able to do it in exhaustive detail because the time doesn't allow for that, but I will describe to you some of the coming powers that we may have soon or in the distant future that will require us to ask some of the same questions that we're asking now. So I will meditate first on the past and the present, then I'll talk about the future, then I'll get to what interests people like me, namely, how should we govern ourselves in this particular domain? And what I will do is make 10 suggestions, 10 modest suggestions for rules of engagement, if you will. 10 questions to guide our discussion and our interactions with one another in thinking about how we should govern ourselves rationally and humanely in this particular domain. And then after I articulate briefly the 10 rules, I will try to give further content to them by reflecting on how we have not observed these rules in the ethical conundrum that we faced even at the beginning of the 21st century. So, let's look back. Let's start by looking backwards and looking at where we are now. The 21st century, and 21st century is a little bit of an arbitrary starting point. I mean, we could obviously go further back, but this is only an hour-long presentation. So I'll start with the 21st century. A lot has happened in the area of bioethics. A lot has happened in science and technology. A lot's happened in the governance, in the jurisprudence, and in the political science of bioethics. In 2001, we saw federal laws banning human cloning, banning various applications of human cloning, introduced in the House and Senate. In 2001, the first announcement, the first public address by President Bush, the newly elected President Bush, was devoted to an issue of bioethical import. That's the first time that's ever happened in human history, in the United States history. They're not the same thing, despite what some would say. President Bush gave a speech on the ethical principles, the moral and ethical principles that animate his policy for the federal funding of embryonic stem cell research and other forms of stem cell research as well. That was a big moment for bioethics. It was a big moment for law. It was a big moment for the governance, self-governance of science and medicine according to ethical principles. In 2003, we saw Louise Brown's 25th birthday. The first child conceived and born alive using IVF. She turned 25 in 2003. It served as an opportunity to revisit and discuss and think about the questions, the ethical questions, the legal questions, the practical questions that are raised by the practice of assisted reproductive technologies. Also in 2003, we saw another bill introduced into the U.S. Congress. It was a bill sponsored by Representatives Castle and DeGette, seeking to further enlarge President Bush's funding of stem cell research. It has not, it passed the House without a veto-proof majority last year. It has not yet been raised in the Senate. 2004, that brings us to 2004. 2004, we were told that stem cells, embryonic stem cells, had for the first time ever, and the only time since, been isolated from cloned human embryos. We learned that the scientists in South Korea had successfully derived usable, functional embryonic stem cells from cloned human embryos using somatic cell nuclear transfer, which is the process that I'm sure you're familiar with to produce cloned human embryos. What you do with cloned human embryos after that is further defines what kind of cloning you're talking about. President Reagan died in 2004. That caused us to reflect on the human meaning of decline, dementia, death, specifically located in the context of Alzheimer's. It also re-energized, in some respects, our discussion about embryonic stem cells and cloning, and I'll return to that in a moment. We had a presidential election in 2004. In 2004, the presidential election featured, again, bioethical issues. The matters of cloning and embryonic stem cell research were brought up at both parties' national conventions. They were mentioned explicitly in the debates between the two candidates from the two major parties, and it was a live political issue that had an impact on our election. In 2005, we learned that the scientists in South Korea had been unethical in very deep ways in obtaining the massive number of human ova that are necessary from women through superovulation, through the process that my friend and colleague and teacher Bill Hurlbut described. Dr. Huang and his staff had paid a number of very poor women to donate their eggs in violation of many, many canons of research ethics. They had solicited the eggs for use in their experiments from subordinate employees, which I don't even need to tell you. Even as a non-lawyer, you can see the problem with that, with the conflicts of interest that are created and the coercion that's involved. So that was our first, that was sort of the first crack in the edifice of our understanding of the South Korea experiments. 2005, Terry Schiavo died. That was another opportunity to have a national discussion on what we owe to the suffering, the relationship between cognitive impairment and human dignity, the sort of autonomy interests, whether or not you can govern yourself from beyond competence. What the proper role of the government is in this particular context. Should it be left up to courts? Could state legislatures or executive branches, or the federal Congress, or the U.S. president get involved in these sorts of questions? It was a fertile ground to discuss those very difficult and vexing issues. In 2006, this year, we learned more about the South Korean experiments. Not only was it the case that they were unethical in very serious ways in obtaining the ova from the various women for use in their experiments, but also they were fraudulent. They falsified their data. They did not, in fact, derive embryonic stem cells from cloned human embryos. They were not the first and only, which means that no one has ever derived embryonic stem cells from cloned human embryos. More on that in a moment. We saw the U.S. Supreme Court in 2006 declare that the United States Attorney General, acting pursuant to the Controlled Substances Act, is not permitted to define the meaning of legitimate medical practice in the context of assisted suicide when there is a state law that's been enacted that takes a different position from the Attorney General and from the U.S. Department of Justice. An interesting question, maybe more interesting to lawyers than anybody else. It really wasn't a right to die case. It was actually a very complicated administrative law case, which you probably would go to sleep if I explained to you. Finally, if you're not asleep already, in 2006, we had a State of the Union address. In the State of the Union, 80 million Americans watching. President Bush called for a ban on human cloning, creating or implanting embryos for experiments, creating human-animal hybrids, and buying, selling, or patenting human embryos. That was a first, to say the least. Talking about hybrids and cloning and selling embryos and patenting embryos and implanting embryos solely for the sake of research. In the most important address that the President of the United States gives annually, there was a pride of place given to those particular bioethical concepts. So, we've been through a lot in this very young century. A lot of stuff has come up. We've talked about much of it over the past 2 days. And it is in these contexts of human reproduction or procreation, contexts of scientific research involving embryos, scientific research touching the beginnings of human life, questions about aging and the end of life, what we owe to the suffering, what we owe to those who are suffering from dementia, what that means, what personhood means when the mind goes. These are the questions that we've been debating. And it's in these contexts that the new challenges are arising. And I'll tell you a little bit about that. I've divided the new challenges roughly into the contexts of medicine, more specifically assisted reproduction or making babies, and then I've just sort of divided from that scientific research. So I'll talk about the bedside, I'll talk about the bench, but in the context, but you'll notice when I raise these subjects that in some cases they could sort of fit both descriptions. And particularly in the context of assisted reproduction, it's very difficult in many cases to distinguish experiments from therapy or the practice of medicine from research. And by the way, that's owing in large part to the law, because the law has blurred those distinctions. The law has allowed the activities to grow up in many respects unmolested by the strictures of the law. And as a result, we have difficulties distinguishing these categories and contexts. So that's a very small object lesson about the significance of law to the questions of bioethics. So let's talk about making babies. Let's talk about assisted reproduction. What's coming? What's on the horizon? We've talked about what's here. There's a lot of sort of crazy stuff or exciting stuff or terrifying stuff, depending on your perspective, here now. Let's talk about some speculative matters. These also we mentioned, and obviously these can be found, and further discussion of them can be found in the President's Council on Bioethics Report, Reproduction and Responsibility, which we issued in 2004. First thing I want to talk about is something called oocyte nuclear transfer. What is that? Oocyte nuclear transfer, it sounds like somatic cell nuclear transfer, but it's not. Oocyte nuclear transfer involves the transplanting of the nucleus from a fertilized human egg into an enucleated fertilized human egg. In somatic cell nuclear transfer, you use the skin cell's nucleus, a somatic cell's nucleus. In this context, you use the nucleus of a fertilized egg. And by the way, I'm using the phrase fertilized egg in a very technical way. And this is important to understand the debates and to formulate meaningful opinions about these questions. The word fertilized egg refers to an egg at a very specific moment. Okay? Fertilization, as we know, is the moment the sperm penetrates the egg. That's the beginning of the process of fertilization. But when the pronuclei of the sperm and the egg, which are the packets that contain the genetic information, the sort of half and half sort of genetic profiles that are coming together in the context of conception, when they come together and the pronuclei fuse, you no longer have a fertilized egg. This is about an hour after the penetration of the egg by the sperm. At that point, you have a zygote, which is a whole and not a part. It's a human organism. It's distinct, genetically distinct from its biological progenitors, if it's sexual, if it's created through sexual reproduction. A little different if it's the context of cloning. But anyhow, what I'm not talking about, that's called syngamy, the combination of the pronuclei, which brings into being a new organism, a new whole organism, self-directing, genetically distinct, and so forth. What I'm talking about is the hour before that, in which you have an egg that's been penetrated by a sperm, but no new organism has been created. It's at that moment that you extract the nucleus from one and transfer it into the enucleated fertilized egg, which was at the same stage of development, right? And what is this for? This is for women who want to conceive biologically related children whose own eggs are defective in a way that can't support the cellular processes that are necessary for conception and gestation of the new organism. So you've got a nucleus with all the genetic information about this particular individual, and you have to house it in a new egg that's healthier and more energetic and whose mitochondria is not as defunct as the original woman. Okay? That's the purpose of this. What's weird about this? Well, if from the description, and I use the word weird, it's not a legal term, but it's not even an ethical term. It's purely a human term. Anyhow, the resulting organism could have the genetic contributions, could have the biological progenitors of the new organism receives the genetic contribution of more than 2 individuals. So you have a new person, a new human being, who has genetic components of more than 2 people. And that obviously, in China in 2003, researchers reported achieving a triplet pregnancy using these sorts of embryos, though none of the fetus survived to birth. And the Chinese researchers attributed the death of these fetuses to substandard obstetrical care, not for anything intrinsic to the process that conceived these embryos and fetuses. So that's the first thing. We have oocyte nuclear transfer. A lot to think about, a lot to talk about. What else do we have? In the context of assisted reproduction, there have been technology, we have new powers for the acquisition of gametes, new ways to get sperm and egg. One way, a new way, a speculative way of getting eggs are from fetuses, are from aborted female fetuses. Researchers have begun investigating whether ovarian tissues from aborted fetuses may be developed in the lab in hopes of one day providing mature eggs suitable for IVF. In July of 2003, researchers announced that they obtained ovarian follicles from aborted fetuses aged between 22 and 33 weeks gestation, and they were able to develop the follicles in culture to a secondary stage. They're hoping someday to be able to generate from fetuses eggs that can be used in IVF. So the child born as a result will literally have a fetus for a mother. Obviously, there's a lot to think about, a lot to talk about, a lot for the law to weigh in on once we've settled, first of all, the scientific questions, secondly, the ethical questions, and third, that's when the law gets involved. Also, there are derivations of gametes, sperm and egg, both from embryonic stem cells. And that is an interesting development. Potentially, if this works, and they've achieved it in mice, if in people this could work, what you could do in principle is to take from me, not me personally, but someone like me, a skin cell, take the nucleus from the skin cell, use it as the nucleus for somatic cell nuclear transfer, create a cloned embryo, which would be genetically virtually identical to me, disaggregate it for its stem cells, and then with those stem cells you try to tease them on a developmental trajectory that will yield either sperm, which is not as weird, or egg, which is a little bit weirder, right? I mean, I could generate usable ova from my own body for use in IVF. And this has a lot of interesting implications. One implication is that the child born in some technical way, their parent would have been an embryo, and I would be their grandparent, maybe. The more interesting sociological and cultural and political possibility is that you could have same-sex couples conceiving biologically related children. And the way that would work is you would take the one man, in a same-sex male couple, you would have the one man use cloning to extract stem cells, tease the stem cells into egg, and then the egg would be fertilized by his partner, by the sperm provided by his partner, and the result would be a baby that is genetically related, biologically related to his 2 male parents in the same way that a child conceived through IVF would be. What else? We have the possibility of uterus transplants. Uterus transplant in Saudi Arabia. It's another highly speculative research area that involves the uterus transplants. It contemplated as a means to enable women with damaged or absent uteri to bear children. So there are all sorts of interesting and troubling, maybe, or exciting, maybe, new possibilities that are being promised by our powers of technology and science and medicine that are brought to bear in the specific context of making babies. Dr. Hurlbut-Bill mentioned the notion of PGD, pre-implantation genetic diagnosis, for screening of non-medical traits. We already screen for sex selection, or family balancing, depending on how you want to describe it. That very well may be the case that it's not likely that you will ever develop genetic screening for very complicated traits or very interesting traits, because they have many different genetic influences, they're not single gene, and similarly they're developed in accordance with certain environmental factors. So it may be the case that there are permanent limiting principles that will restrict what we can do with genetic screening for elective purposes. But as you all know, the market will gloss over those limitations, and people will still pay a lot of money to give their child an additional opportunity to have a high IQ, or to be very tall, or to play the piano. So that's in the context of making babies. What about in the context of scientific research? Well, let's talk a little bit about embryonic stem cells. We all know that embryonic stem cells are highly valued for their speculative potential to become any type of tissue in the body, both for purposes of modeling diseases and for the development of therapies. But something that we're going to have to contend with in the very near future is that the aspiration of those in the medical and scientific community who promote embryonic stem cell research, their aspiration is to develop a multiplicity of very diverse lines that are both genetically diverse and diverse in the sense of the diseases that they can model. They want many, many, many embryonic stem cell lines so they can study the progress of certain diseases, but also so that they can potentially develop therapies that will be useful for a variety of injuries or ailments. And so one very eminent embryonic stem cell researcher, Bob Lanza of ACT in Massachusetts, said that what this project will require is millions of human embryos necessary to generate these sorts of lines, and not just genetically diverse, but also racially diverse, because minorities are underrepresented among the spare embryos that are available in so-called spare embryos that are available in freezers around the country. But Will Saltan of Salon.com wrote an article or a column a while back suggesting that there's a collision course between those who oppose embryo-destructive research and the practice of IVF, since IVF invariably creates surplus embryos that are destroyed and requires research that destroys embryos to support. But I think the more likely collision course is between those who have aspirations to develop these very diverse lines of stem cells and the scarcity of surplus embryos. There are 400,000 embryos in cryopreservation in the United States, according to RAND. And that sounds like a lot, but then RAND also studied the preferences of those parents or biological progenitors, or however you wish to describe them, who have conceived these embryos. And only 2.8% of parents who have frozen embryos in cryopreservation are willing to donate them for use in research that will ultimately result in the embryo's destruction. And it's interesting because, as a sociological matter, it's interesting. It'd be interesting to drill down a little more into the social science data in this area, because it costs about $1,500 a year to keep embryos in cryopreservation. And it's pretty clear from the ages and the amount of time many of these embryos have been in cryopreservation, the parents of these embryos aren't seriously going to use them for future reproductive cycles of their own, even though that's what 90% of them say on the informed consent forms that they execute. So there's something interesting going on. But if there's 2.8%, that translates to about 11,000 embryos under the maximally optimistic scientific atmosphere and circumstances. That will yield about 245 extra lines. And that is far short of the lines necessary to yield the promise that these stem cell researchers are hoping. And that leads us directly into the requirement of creating embryos solely for the sake of research, either through cloning or through conventional IVF or through some other mechanism. So this is the first issue that we're going to have to contend with in the context of scientific research, is the scarcity versus the desire for embryos for use in stem cell research. Additionally, we're going to require, there's a move in the future that we're going to have to contend with for extended culture of embryos. Right now, it's not possible to keep an embryo outside the body for an extended period of time, something like 7 days, 8 days, and then they can no longer sustain their own lives. But nevertheless, it would be extremely useful for scientists to extend that amount of time so that they could study the development of the embryo. It would yield interesting insights and important insights into embryogenesis. It would also possibly yield insights into the developmental movements of certain diseases. So there are moves underfoot to find ways to preserve, and there's an additional reason, which is to say organ primordia are actually more valuable than undifferentiated cells. And what do I mean by that? Well, with embryonic stem cells, you take a wild card cell that you can tease along a developmental trajectory to become something that you want it to become. In many cases, it's some sort of organ primordia, a pancreas or a kidney or something like that. It's a lot easier to actually have an organ primordia than to have to make one. And how do you have one of those? Well, you do that by extended culture. You gestate the embryo for a longer period of time and fetal organs form, and then you take, their primordia form, and you can take them directly for use in therapeutic and research purposes. So scientists have been developing different mechanisms for extending culture of embryos outside the body. One of the possibilities is ectogenic chambers. Very speculative, hasn't been demonstrated that it's possible for any extended period of time, but there are scientists in Tokyo who are working on the first artificial womb which is another word for an ectogenic chamber. They keep goat fetuses alive for up to 10 days by connecting their umbilical cords to 2 machines serving as a placenta. And they claim that they'll be up and running in 6 years for full gestation, full term of organisms outside the body that require in vivo gestation. Take the word with a grain of salt. People often promise things that they can't deliver, but that's the claim that they're making. Similarly, at Cornell, Dr. Liu has created, there's a woman named Dr. Liu who's created an artificial endometrium and had human embryos implant in them. An artificial endometrium, the endometrium is the lining of the uterus in which the embryo implants. Artificial endometria in which human embryos have in fact implanted themselves, and they began to develop, but the scientists destroyed them at 6 days development. It will be interesting to see how that works out. An alternative method for extending the development of embryos for purposes of research and potentially therapy are pregnancies, human pregnancies undertaken solely for the sake of research. In fact, recent experiments in animal cloning, the only successful SCNT experiments involving animals, have required the transfer of the cloned animal embryo to a uterus for gestation for a certain period of time before you could get the usable germ cells. Embryonic germ cells, not embryonic stem cells. Not cells that come from the inner cell mass of an embryo, but rather come from the gonadal ridge of an early stage fetus. The only successful experiments involving human cloning, or involving somatic cell nuclear transfer or cloning in animal models, have required transfer of the embryo to a uterus for further development. How soon on the horizon are we for human individuals doing something like this to try to generate research material or to help with therapies? Well, a law passed in New Jersey, the law passed in New Jersey to endorse and fund and promote stem cell research, in fact, defines human cloning as the cultivation of the cloned human organism through the newborn stage. It's not time limited. The only way you are guilty of cloning, reproductive cloning in New Jersey, is if you cultivate the organism through the newborn stage. It doesn't mean you can't transfer it to a woman's uterus. It doesn't mean that you can't gestate it through 9 months of pregnancy and then take it out and take its organ primordia for use in research and hopefully therapy. So it very well may be the case that these are closer than we think. And there are federal laws, you might ask. Are there federal laws that relate to fetal tissue research, or the use of fetal tissue in research? Yes, there are, but they don't capture this particular species of activity. Under the federal law, it's a crime to designate the specific recipient of the therapies that are generated from the research involving the fetal materials. So the only thing that is actually illegal is to buy a fetus for valuable consideration, which is what lawyers mean when they say for money, is what that means. Or to pay for a woman's abortion so that she can give you the fetal remains for purposes of research. Or it's illegal for the woman to designate either a relative or a known individual who will receive the therapies that arise. But there's nothing limiting altruistic establishment of a pregnancy for the sake of generating a fetus for use in research, so long as you don't designate a relative or of a person that you know who will benefit from therapy, if any benefit accrues. Two last things I'm going to talk about in the beginning of life stage, and then I'll mention something else briefly, and then I'll turn to my rules of engagement, if you will. There are moves afoot. There's a great desire to patent human embryos. There's currently an appropriations rider that attaches and is renewed each year in congressional legislation that prohibits the use of essentially prohibits the Patent and Trademark Office from issuing any patents on human embryos. But again, that's a temporary measure, and bio and other business interests and scientists and so forth have expressed deep interests in securing intellectual property rights in embryos themselves. And so that's something that we're going to have to continue to think about in the future. Also, finally in this domain, something that has been talked about a little bit more recently is the generation of what are called chimeras and hybrids. We talk about this a little bit in the President's Council report and in our transcripts on the website that Dr. McHugh mentioned yesterday. Hybrids and chimeras, what are they? Well, they're biologically different. They're organisms. A hybrid is an organism that has genetic material in each cell from two different sources. For example, a mule is a hybrid of a donkey and a horse. In each cell inside of a mule, you have both donkey and horse genetic material. A chimera, by contrast, taken from the ancient literary reference, is an animal that has some portion of cells in their body that are foreign, that are of some other species. For example, a pig that has a human kidney in it that's gestated to develop for transplants in people, that's a chimera. That's not a hybrid. And by the way, I should say, not all chimeras are ethically problematic or suspect at all. In fact, many animals with human organs, sheep with human livers, pigs with certain organs, are less obviously problematic from an ethical perspective than others. But there are some sorts of mixing that raise interesting questions. For example, at St. Kitts Biomedical Foundation in the Caribbean, scientists are transplanting immature human brain cells into the brains of vervet monkeys. Their goal is to develop a treatment for Parkinson's disease. They inject immature human brain cells in the dopamine-producing area of the monkey's brains to see whether cells can grow and increase dopamine production. So it's the introduction of human cells into primate brains. Similarly, at Bill Hurlbut's Stanford, there is research underway that injects human neural stem cells into mouse fetuses. And the result is that you have a mouse with a brain that's about 1% human, which is to say composed of human cells. The aspiration is to develop a mouse brain that is composed of 100% human cells so that they can understand developments in Parkinson's, Alzheimer's, and Lou Gehrig's disease. But there are questions about whether or not there's an ethical concern about a non-human animal that has a brain that's composed of human cells. And in certain it's not immediate. It's obviously, I'm certainly not suggesting that the resulting animal would have some sort of human consciousness, or you'd show up one day and the mouse would have a diaper on because he was embarrassed that he was naked, or we would talk to you or something like that. I'm not suggesting anything of the sort, but there are interesting questions. In fact, there's a working group on interspecific chimeric brains, and the most sort of problematic question, which is to say the insertion of human brain cells into the brains of primates are more closely related to us biologically than mice. And this is a direct quote from Mark Green from the University of Delaware, who's a member of this working group. And he said, "Many of us expected that once we pooled our expertise, we'd be able to say why human cells would not produce significant changes in non-human brains. But the cell biologists and neurologists couldn't specify limits on what implanted human cells might do, and the primatologists explained that gaps in our knowledge of normal non-human primate abilities make it difficult to detect changes, and there's no philosophical consensus on the moral significance of changes in abilities if we could detect them." So, there are certain ethical concerns that we can talk about that are implicated by this sort of generation of a particular kind of chimera, especially involving the brain of non-animals that are composed by human brain cells. One final point is that, involving chimeras, is that it's possible in principle for a chimera, which is to say an animal that is mostly animal but has one human function or one human principle working inside them, could mate with another animal of a similar chimeric design and yield an offspring that's human. How would that work? You'd have a mouse that could produce human sperm cells, thus making it a chimera, and have it mate with a mouse that produces human egg cells, and through that sexual reproduction you could possibly yield something that is a human being whose parents are both non-human animals. Finally, last example in the context of hybrids and chimeras. I'll stop listing things and then get into the rules of engagement, which is, I think, more relevant and more interesting for my purposes. Finally, there are research underway since 2003 to develop rabbit-human hybrids. That is to say, not a chimera, not a rabbit that has one human part, but rather an embryo that has both DNA from rabbits and human beings in every cell in the body. The researchers in China did this at Shanghai Second Medical University. They developed these embryos, and they had mostly human DNA and a small amount of rabbit DNA. The researchers harvest the stem cells after a few days and then destroy the embryos. Lastly, and at the other end of life, my colleague Eric Cohen yesterday spoke very eloquently about the coming demographic explosion of people suffering from dementia. People are living longer, which extends, in many cases, an individual's decline. And as our powers to extend bodily life increase, we're going to have to grapple with the social meaning of having a population with so many folks suffering from dementia, what we owe to these people, how we care for them, and so forth. Related to that, there are states now considering further legalization of assisted suicide, and abroad, the Netherlands have just adopted a protocol for the euthanization of disabled infants. So we're going to have to grapple more in the future in a more intensive way as the population increases with these very serious questions that we've been grappling with all along. So everything that I've talked about, all these new things, all these novel things, they're surprising possibilities. They are exciting depending on your perspective. They are terrifying depending on your perspective. But there's no way around the fact that we're going to have to figure out how to govern ourselves and govern our science and our medicine according to the ethical principles that we arrive at when we debate and discuss these particular issues. And so the good news is, I don't think the rules change for us, even though the factual contexts do. I think we should observe the same rules of engagement. We should observe the same process. Lawyers love process. I'm about to give you a process that I think will yield meaningful self-governance that is both humane and reasonable. How do you do it? And I think it doesn't matter what the issue is, looking backward, looking forward, I think these 10 suggestions embrace both the past, present, and the future. First of all, and I'll go through these quickly. First of all, our first rule of engagement is to slow down. And what do I mean by that? Well, our powers of technical mastery explode. We can do things that we've never been able to do before, and that's a process, and that's not slowing down. Our powers to subdue nature, to remake nature, to both improve ourselves and improve our lives, and to satisfy our desires, that is proceeding apace. But the problem is when that gets ahead of our own understanding of the proper ends to which these particular powers should be directed. And it's a perennial problem. Our moral reasoning is slower, our deliberation is slower than is our own power. So we have these powers, we don't know what to do with them. And the powers themselves are silent. They don't tell us how they should be used. They leave it to us to make those determinations based on our moral reasoning, our ethical principles, and ultimately the law takes cognizance of that and memorializes it and enforces it. So we have to slow down and harmonize the pace of our technical mastery, or at least our application of this technical mastery. That's not to say research should slow down, but rather our use of these new powers should slow down until we understand what they're for, what they should be for. Secondly, I think we should embrace the notion that these are political questions. And Dr. McHugh spoke very powerfully about this last night. These are political questions. The question of the human meaning of these new powers and the applications to which they should be applied. These are human questions. These are not scientific questions. To be sure, as Dr. McHugh said last night, you have to understand the science inside and out and know exactly what you're talking about before you start moral reasoning, before you start debating about the ethics of a particular practice. You have to understand what it is. But and science contributes to that, obviously, and scientists contribute to that. They explain what are the mechanics of this? What are the mechanics of embryogenesis? When does the neural streak form? What is and so on and so forth. But ultimately, they have nothing to tell us when it comes to making moral judgments about the rightness or wrongness of applying these new powers. It's political. In our democracy, in our system of government, thankfully, we govern ourselves. We talk about these matters, we deliberate about them, we reason about them, we come to conclusions, and then we make laws. And the fact that two important implications flow from the fact that these are political questions and not scientific questions. One, it's not fair to raise the claim as a criticism that you're legislating morality. You're legislating morality when you ban stem cell research, which has never happened at the federal level, by the way. You're legislating morality when you limit our capacities to create animal-human hybrids or chimeras. Well, that's true. That's a descriptively true statement. But a pretty good definition of law in an American republic, in our country, is that law is morality or moral judgments that have been memorialized and are enforced through the coercive power of the state. That's what law is. You can reduce any law to an underlying moral and ethical principle. Every law aims at a particular good or seeks to avoid a particular harm. And it is not a fair criticism to say we're legislating morality. That's what law is. Law is moral judgment backed up by the coercive power of the state. Every single law can be reduced to a moral principle. Even laws like the speed limit, which doesn't seem, what is this? What's the moral principle underlies the speed limit? Well, that resulted, the speed limits are generated through a balancing process of determining the desire for efficiency and being able to drive quickly from place to place versus the desire to save human lives and minimize accidents. Speed limit's 55. If one of those two values were to predominate, if we only cared about human safety, the speed limit would be 1 mile per hour. We wouldn't be allowed to drive cars. If all we cared about was efficiency, the speed limit would be 150 miles per hour, or it would be limitless. So even something that seems like a pure regulation without any moral content can be reduced to a moral principle. And so it's not ever fair to say, you're legislating morality. Well, yeah, what are you doing if you're not legislating morality? Are you just arbitrarily saying you can't do something without a pre-existing moral judgment? I think that's a bad idea, and I don't think that's what law is. Secondly, the second implication of understanding these are political questions, and this is again echoing my friend and colleague Paul McHugh, everybody has standing to discuss political questions. Right? Standing, that's a legal concept. Standing means you are authorized to speak. You're authorized to bring a lawsuit. You bring a lawsuit, you don't have standing, the court says, you have no interest in this, you have no stake in this. Go away. You have to have standing to bring a lawsuit, you have to have standing to enter an argument. Everybody has standing to enter arguments about what it means to be a human being, about what we owe to the suffering, about what we owe to organisms at the beginnings of their lives, at the end of their lives. These are the questions of bioethics. They're political questions. They're not to be settled by scientists. They're not to be settled by bioethics experts. Science doesn't answer ethical questions. Nuclear physics doesn't tell me about the moral permissibility of nuclear war. That's a political question that everybody has a stake in and everybody can talk about, and your voices should not be silenced, and you should not feel intimidated because you're not a scientist. You shouldn't feel intimidated because you're not a bioethicist. You are as free to talk about this, to weigh in on this conversation as anyone else. Closely related to that is rule number 3. In order to govern ourselves rationally and humanely, we have to clearly understand and articulate in a clear and open way the goods that we seek to defend and the harms that we seek to avoid. As I said, technology is instrumental. Medicine is instrumental. Ends are moral. Ends are political. And you have to say what you're talking about. You have to say, I'm for this because I'm worried about X. I'm not for this because I want to promote Y. I'm for scientific freedom. I'm for the alleviation of human suffering. I'm for protecting the vulnerable and the voiceless and the marginalized. These are ends. This is where you start the moral discussion, the political discussion that yields ultimately laws and self-governance. And fourth, we have to call things by their right names. And this is a point powerfully made by the President's Council on Bioethics. When you're talking about technical matters, you cannot avoid vexed moral disputes by using words that obscure those disputes. You have to speak clearly about what you're talking about. You have to call things by their right names. And I'll give further content to that in a moment. Fifth, you have to be honest about the promise and the perils of the science that you're going to pursue, or be honest about the implications of not pursuing a particular scientific approach. Sixth, we have to be honest about our ambitions and what they require. We have to say what we want to do, we have to say why we want to do it, and additionally we have to be honest and open about what it's going to take to get there. What does it mean if you want to have a completely genetically diverse array of embryonic stem cells? How's that going to work? What does it mean if you want to engage in somatic cell nuclear transfer experimentation on a massive scale? What follows from that? Back to that in a second. Number 7, you have to fairly characterize opposing arguments. And before that, you have to understand the opposing arguments. If you're locked in a disagreement with someone, you have your obligation as a member of a self-governing democracy is to understand what it is that they're saying, what are they trying to get at, what are their values, what are they promoting and defending, and how is their argument constructed, what's the most important strength of their argument, what's the weakest point of their argument. So you have to fairly characterize it. You can't make a straw man. You can't say, oh, opponents of embryonic stem cell research think that cells are people, think that cells are the same thing as a full-grown man. There may be some that hold that view, but that's not the most potent argument against embryonic stem cell research. And so to meet that argument, while A, being a very easy and simple thing to do, B, it's not helpful. And it, in fact, doesn't advance the debate. It doesn't advance the project of meaningful and rational and humane self-governance. 8, you have to be responsive to the opposing arguments. You have to fairly characterize them in the first instance, and then you have to respond to them. You have to say, the strongest point that you're making is this. I disagree because of the following reasons. And I'll give, again, further content to all these when I reflect on how these rules have been misapplied in the past and in the present. 9th, you have to be open-minded. And this sounds sort of Pollyannish, and it sounds sort of sweet. And be open-minded, and everybody has an important point of view, but it's absolutely crucial. Be prepared to be surprised and persuaded and to challenge your own views and to think about, well, I never thought of it that way, or this is a lot more complicated than I thought it was before. That's absolutely crucial to a useful process of moral reasoning and then by extension self-governance. Finally, and 10th, you have to be civil and be charitable. You can't call people names, you can't, it detracts from the atmosphere that's necessary, the necessary groundwork for meaningful discussion and debate, and ultimately self-governance. You have to be civil and you have to be charitable. Okay, so these are 10 rules. I think they should always be looked to when tackling these particular very novel and interesting and exciting and troubling and terrifying things that I've mentioned. But that's looking forward. Let's look back again for one more second, and then I'll conclude, to get some further guidance as to how not to apply these principles. Our debates have been impoverished, let's be honest. We've not benefited from most of the public discourse, with some very limited exceptions, including, I think, the deliberations of the President's Council on Bioethics. That's been enormously helpful to the public discourse. And Paul McHugh and Bill Hurlbut are owed a great deal of thanks for that, as members of that body. But I would say that most of the discourse has been very bad and very weak and not helpful, and has not promoted the cause of good moral reasoning, ethical reasoning, and is not promoted, by extension, meaningful self-governance. Why not? Let's look very quickly back at how these 10 rules have been applied to the problems of the past, the problems I started with: embryonic stem cell research, cloning, end-of-life matters, Terry Schiavo, everything we've been talking about for the past couple of days. Rule number one was slow down. Rule number one was, let's harmonize the pace of our understanding of the proper ends of these powers with the powers themselves. Let's not get ahead of ourselves. Let's not be like a toddler that can swing a bat before he can understand that he's hitting mommy in the face or knocking a vase over. Right? We're not good at that. We plow forward. It's easy. I mean, it's not easy. Scientists, bench scientists, we have a massive debt we owe to them for doing all the hard work of generating these new powers. But in contrast to moral reasoning and understanding what these powers are for, that's actually pretty easy, as hard as it is. And we have to understand the human meaning of our powers before we exercise them. Dan Callahan talks about the research imperative, where the phrase, should we do this, has been replaced by, can we do it? If we can do it, we should do it. And I think that's a formula for disaster. And in the context of the debates that we've been having, I think that we've not slowed down enough. We have not talked enough about the human significance of utilizing human organisms at the earliest stages of development, and how that relates to what we owe to the suffering. But we haven't talked about that enough. Even though it seems like we've talked about it a lot, we haven't talked about it well enough before we can move forward with questions about who should and shouldn't pay for embryonic stem cell research, or which center is going to waive its real estate fees in California so it can be one of the centers according to promote Proposition 71. So we have not slowed down. We've been pretty fast, irresponsibly so. 2, embrace the notion that these are political questions. We haven't done that. We've ceded the ground to scientists and bioethicists. Scientists and bioethicists have told citizens to be quiet. They're the experts. They'll settle these matters. No reason to trouble yourself with these very complicated questions. Go back to your ditch digging or whatever. We haven't done that. And we really haven't understood and articulated clearly and openly the goods we seek to defend and the harms we seek to avoid. And what I mean by that, and one thing, and to give further content to that, I'm talking about defining principles in a rich way. Paul McHugh last night talked about the thin bioethics and the thick bioethics, the rich bioethics. And I'm here to echo his argument for the rich bioethics. We're not arguing about how should we most promote advanced directives or living wills, or what do we think about artificial nutrition and hydration. That's not a principle. That's an ad hoc approach to a particular concrete question. The principle is, what do we owe to the profoundly disabled? What does death mean? What does dying mean? What's the human meaning of these phenomena? What do we owe to the suffering? What do we owe to those people who are profoundly disabled who are not suffering? What do we owe to those but whose condition bothers us? What do we owe to those profoundly disabled people who are dying, who aren't dying imminently? But those are big principles. Those are big questions. Those are rich questions to ask. Those are the questions we should be asking. In the end-of-life context, we haven't been asking those questions. We've been asking questions about the content of an advanced directive. That's not helpful. In the context of assisted reproduction, we've similarly not been defining the basic question. The basic question is, what is the human meaning of conception, pregnancy, and birth? What is the human meaning of the relationship among the generations? These are questions that are squarely presented by advances in biomedical science and assisted reproduction. They're front and center in the question of reproductive cloning. But instead, we're all content to be quiet about reproductive cloning because we can all agree about safety. Well, that might be an evanescent concern someday. Who knows? And then where will we be? We won't have discussed, we'll have some cloned baby, and we won't have talked about the meaning of these deeper questions, and won't be able to govern ourselves as a result. And then also in the context of research, cloning for biomedical research, cloning for irregular embryonic stem cells, we haven't asked the questions in the right way. We have to ask, what does it mean for a society to affirmatively promote and endorse an enterprise that requires the destruction of nascent human life? That's a deep question. That's a question that is rarely raised specifically and directly and debated in our culture in a public way. Alternatively, you can say, what does it mean for a pluralistic society to restrict scientific enterprise based on a contested ethical principle? It's a deep question. We haven't been asking it. Number 4, calling things by their right names. We've had a serious problem here. Especially in the cloning context is the best example. In the cloning context, the resulting organism from somatic cell nuclear transfer is an embryo. President's Council on Bioethics agreed unanimously, despite the deep disagreements about the permissibility or wisdom of human cloning for biomedical research, agreed that the product is an embryo. Nature magazine, to its great credit, took issue with the fact that there are many in the public debate that are trying to confuse people, either intentionally or unintentionally. They're trying to, or they are confusing them, by using words like pre-embryo, SCNT unit, and fertilized egg for regular embryos that are conceived through IVF. Fertilized embryo, that's an expression that is very strange. But my favorite is unfertilized blastocyst. That is a phrase that appears in legislation before the United States Senate. Why did they pick the words unfertilized blastocyst? There are 2 reasons. Or there's one reason. The reason is to confuse a layperson into not thinking there's any problem. I'm not suggesting to you an answer about the permissibility of cloning for biomedical research. I'm simply saying that you can't solve the problem by saying there's no there there. There's nothing there. There's nothing to see. Unfertilized blastocyst? Find an embryo text that uses that word and I'll pay you $100. It's not there. Unfertilized. Yes, technically it's unfertilized. It's produced through somatic cell nuclear transfer, not fertilization. Blastocyst, well, that means that's an embryo. That's a 100 to 200 cell embryo, 5 to 6 days of development. It's an embryo. People understand when they hear the word embryo, even cloned embryo, that there's some kind of an issue that they should maybe think about before moving forward. But if you hear the word unfertilized blastocyst, it sounds like, what is that? That sounds like some kind of skin sample, or I have no idea what that sounds like. But it doesn't sound like, unless you're someone who's thought about embryology, that doesn't sound like, you can't deduce what that means. It's not a term of art. Now, it's important to distinguish this from what some people have done in terms of legitimately contesting the use of terminology. And we're very fortunate to have Paul McHugh here. Paul McHugh has made an elegant and potent argument that the product of somatic cell nuclear transfer is sufficiently different from an embryo that it should have a different name. Clonote is what he called it. Read his personal statement. I don't know if he published his exchange with Leon Cass, our boss, about it, but it's a very rich exchange. Paul, is that published? No. Okay, it should be. You and Leon, they went back, these 2 giants going back and forth talking about the meaning of talk about these words and what they mean. That's not the same thing. Paul's not trying to confuse people by saying there's no there there. He's saying, I have an argument as to why we should think differently about this product and should call it a different thing rather than an embryo. But that is not the rationale, the noble rationale behind the unfertilized blastocyst. Similarly, it's therapeutic cloning. Therapeutic cloning, the President's Council on Bioethics refused to adopt that expression because there are, in fact, no therapies that have been developed using somatic cell nuclear transfer. Therapeutic cloning, it's speculative. That's not to say that it hasn't happened, that it won't happen in the future. I'm not suggesting to you that it's not possible that a therapy will arise out of somatic cell nuclear transfer, even a very beneficial therapy. But it's not here yet. And the most honest scientists will tell you that it's not here, it's not going to be here for a long time. The South Korean debacle showed us that, in fact, no one has even gotten a usable embryo from the process of somatic cell nuclear transfer. In animal models, the only way that they've yielded beneficial developments is through the transfer of the cloned embryo to an animal uterus and gestate it to a fetal stage and take its embryonic germ cells from the gonadal ridge of the early fetus. So therapeutic cloning is a political slogan. It's not a term of art, bioethical, legal, or scientific. And being honest about the underlying facts and calling things by their right name applies to the legal matters as well. As a lawyer, when I hear people say there's a ban on embryo research imposed by the federal government, I cringe because it misunderstands the richness of the notion of regulation. The government does more than ban and permit. The government permits with restrictions, the government endorses and funds, the government stays silent. And because the government's not paying for something doesn't mean that it's banned it. It's not even the case that the government doesn't pay for embryonic stem cell research. In fact, the lines that have been approved by the present administration's policy are robustly funded. And in fact, all of the experiments, the animal experiments that I was telling you about, all of the most prominent experiments involving animals, animal models, and human embryonic stem cells, virtually all of them come with embryonic stem cells that were approved and funded by the federal government. So refusing to fund is not the same thing as banning. Witness California, which just passed a $3 billion piece of bond that will fund all manner of embryonic stem cell research, including cloning for biomedical research. If it's banned by the federal government, the people in California haven't heard about it, although it is hung up in litigation about some good government issues. Fifth, being honest about the promise and perils of the science. Have you seen the Korean stamp? Have you seen the South Korean stamp? I wish, if I weren't, one, technically disabled, I can't use a PowerPoint. I don't know how to do that. I'm also a lawyer. I don't like documentary evidence of the things that I say floating around, so I don't write anything down. I will describe to you the South Korean stamp. Issued when Dr. Hwang announced his great successes in developing embryonic stem cells. You have different, superimposed over the backdrop of a cloned embryo, a blastocyst that is having, or the inner cell mass of a blastocyst that's been extracted. You have, in the first frame, a man in a wheelchair. Second frame, you see the iconic representation of cloning and somatic cell nucleotransfer and developing a stem cell therapy. Next sequence, he's out of his wheelchair. Next sequence, he's running. And the last sequence is my favorite. He's hugging a woman. They're embracing each other. He's so happy. They're celebrating the fact that he's no longer paralyzed because of the promise of Dr. Hwang's work. I don't have to tell you how irresponsible that is. And I don't have to direct you to South Korea to see how irresponsible that is. In the last presidential election, we had a candidate say, in a public forum, if we federally fund embryonic stem cell research more than we are now, people will get out of their wheelchairs. Maybe that was the inspiration for the stamp. I'm not sure. Maybe, but that was a very esteemed senator the senior senator from Massachusetts said that if we fund embryonic stem cell research and pursue cloning, it will clear most all of the beds in the nursing homes in the state of Massachusetts. He didn't elaborate as to why that would be the case. Who knows? But the implication was that we would develop all these magnificent therapies that would get people up out of their nursing homes and out of their... And similarly, being honest about the science means not declaring that adult stem cells are and because of lack of plasticity, because they're less potent, are clearly inferior. There are many who would make that argument. Say adult stem cells are never going to be as useful because they're not as self-renewing, they're not as plastic, you can't use them as much. That's not been shown. That may be the conventional wisdom, but there are recent experiments, as Bill Hurlbut suggested, that some adult stem cells have shown the markers of pluripotency that are useful in the context of embryonic stem cells. So who knows? Similarly, though, I have to say it goes both ways. We can't make claims about things that we don't know in the other direction either. We can't say adult stem cells are superior or vastly superior, will always be superior to embryonic stem cells. We don't know that either. It may be the case, it is true that there are clinical trials and therapies that are derived from adult stem cells and have been for a long time, and that there are no clinical trials and not even any plan for using embryonic stem cells. Embryonic germ cells are different, as I mentioned. They're taken from fetuses and they're taken from embryos. But, and there are some clinical trials planned for those, for that sort of research. But that doesn't mean that next week we won't hear about some unbelievable therapy or some unbelievable experiment where in fact someone benefited, or an animal more likely benefited from an intervention involving embryonic stem cells that we just don't know. And it's irresponsible and dishonest to say that we do know and to say that adult stem cells will always be the best option. And not only that, though, the moral argument, at least the moral argument that's most persuasive to me, doesn't depend on that fact. It doesn't depend on what's the best outcome. It's not a consequentialist concern. If it's immoral to destroy human embryos for the sake of research, it doesn't make it moral because it's more beneficial than we originally thought, unless you have a pure utilitarian calculus, in which case you might be persuaded by something like that. Finally, being honest about the science and meditating on the Korean scandal, we have to be honest with ourselves about the promise of somatic cell nuclear transfer. No one, and I'm not saying again, I'm not saying that it won't work, but no one has ever derived usable embryonic stem cells from a cloned embryo. It hasn't happened yet. We're still waiting. The only person that did it, turns out, paid women for 2,000 ova, some of whom were his inferior, sort of subordinate employees, and then lied about the results. That's the best, that's the closest we've come. Number 6, have we been honest about our ambitions and about what they require? Well, no, we haven't. Originally, we were told that all we want are the surplus embryos in cryopreservation. Then we were told, well, we might have to make some extra embryos to get the sort of genetically diverse lines that we want, but we'll do it through IVF. We won't ask you to fund cloning. We just want you to leave the door open to it. We'll just leave the door open to somatic cell nuclear transfer for the creation of these very special embryos. Well, now last week at a hearing on Capitol Hill, we heard the first call for the federal funding of cloning human embryos. That's something new. It's new in that even Bill Clinton in 1994 rejected the idea that the federal government should pay for an enterprise in which embryos are created solely for the sake of research. It's such an instrumentalization, it's such a total instrumentalization of the embryo, even Bill Clinton thought that the American people weren't ready for it. We have to be honest about our ambitions. Our ambitions in the embryonic stem cell research context require us to have massive number of ova, a massive number of embryos, and we have to be honest about that. To be honest about our ambitions of having a bifurcated law, a law that bans cloning for research, or sorry, cloning for reproduction, and permits cloning for biomedical research, we have to be honest about what that law requires. That law requires embryos that are created through somatic cell nuclear transfer. It makes it criminal, a criminal violation of the federal law to transfer them to a woman's uterus. So as a matter of federal criminal law, you have to destroy every embryo that is created through somatic cell nuclear transfer if we were to pass that law. And that would move our country from a status quo where the government has never funded embryonic stem cell research or any kind of embryo-destructive research, where it's maintained a judicious silence, it can go on in the private sector, we're not going to support it, but we're not going to restrict it, to a regime in which we would have to destroy embryos on penalty of criminal law. 7th, fairly characterizing the opposing arguments. Well, we've done a bad job there too. In the context of cloning and human embryo research, the most potent argument, which I won't rehearse here, you can find it in the personal statements of Drs. Robert George and Alfonso Gomez-Lobo in the Cloning and Human Dignity Report from 2002 of the President's Council on Bioethics. That argument is rooted in the biological, ontological status of the embryo and the continuity of embryological development and the self-directing nature and uniqueness and wholeness of a human embryo, which puts it in the human family. All of us were embryos, as Bill Hurlbut said. The embryo is one of us. It's more accurate to say we were at one point one of them. And the classical liberal political principle of equality. Neither one of those require commitment to any particular religious faith or any faith at all. And yet that argument has been dismissed as a religious argument and therefore not binding on people who are not similarly religious. And I think that is a grave weakness in our dispute. Similarly, closely related, rule number 8, be responsive to the opposing argument, with very few exceptions, although the President's Council on Bioethics, many of the diverse folks in the President's Council on Bioethics, those who favor embryonic stem cell research, those who favor cloning for biomedical research, they have engaged that argument and they should be credited for it, but most people have not. Most people simply invoke their purpose louder. They say, we want to alleviate human suffering, we want people to get out of their wheelchairs. They want people to stop dying of dread diseases. They don't engage the very profound arguments of Professors Gomez-Lobo and George. It may be the case that those arguments don't stand up under scrutiny, but the scrutiny hasn't been brought to bear yet. In fact, the NAS guidelines, the National Academy of Science guidelines, and the Hingston report, the most recent sort of consensus-based report coming out of Johns Hopkins, people from Johns Hopkins, they discuss the guidelines for the conduct of embryonic stem cell research. The Hingston guidelines don't use the word embryo, not as a noun. They say embryonic stem cell research, and they do not mention one time what the moral concern is about the instrumentalization of these organisms. That's a failure. 9th, be open-minded, be prepared to be surprised and persuaded. We've not done a good job with that. A very prestigious and eminent publication announced its editorial policy of pursuing articles that demonstrate a particular fact that is yet to be known. We're going to solicit, we're going to pursue articles that show the promise of cloning and embryonic stem cell research. Well, that is not an example of being open-minded and being prepared to be surprised and persuaded and pursuing truth in a disinterested way and being willing to accept wherever the inquiry leads you. Finally, being civil and charitable. Not a good job. Religious nut. Conservative wacko. Ghoulish vitalist, if you're talking about the end of life. These are words that I've heard a lot. I've also heard the word Nazi, nihilistic, anti-religious bigot, to describe the other side. Mechanist, nihilism, you hate, murderer. These are not helpful words to promote a meaningful and charitable and civil discourse, which we have to have because we've committed to it in our system of government. So hopefully I leave you with to reflect on those 10 procedural suggestions so that we can not only maybe rehabilitate our current discourse on matters that we've talked about, but it will prepare us to tackle the very unusual things that wait for us in the future. Thank you very much.
Thank you very much. Unfortunately, we don't have any time for questions. We've kept the caterers waiting beyond what we thought. So please proceed directly downstairs where dinner is waiting.